Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And our topic today is steps in your family law court matter. In our previous episode, we had talked about the various dispute resolution options if you're going through a separation. And if at this stage you think court is the best process for you, our goal is to walk you through what that entails, starting from the beginning. Correct,
Yep.
Sherine?
And there is a lot of different steps.
Yeah.
And you might not have to go through all of them, but the initial starting point is bringing an application. Now, this is under the assumption that you don't have an existing court order that you're trying to vary, but it's really a new claim that you're starting. And with that, you could bring in your application a claim for a divorce, parenting claims for decision-making responsibility and for parenting time, child support, spousal support.
Let's just say there's a lot.
Literally anything.
There's a page full of claims that you can make, and there's boxes for others. So you can make any claim under
under
the law that's related to your family law matters. So sometimes for efficiency's sake, for example, a claim that you could have ordinarily brought maybe in civil court, if it's connected to your family law matter, for example, it would be appropriate to put it all in there. So that's your application is the starting point. There's forms that go with that depending on what you're
exactly.
You're
so if you're making a claim for support, you do need to attach and also prepare a financial statement.
Mm-hmm.
And depending on if you have property, you would also prepare a more detailed financial statement. And with a financial statement, it sounds as fun as it sounds that fun. It really is kind of all of the financial circumstances, expense budgets, depending on if you're claiming for spousal support, it would add for a proposed budget and things like that. And if you're seeking child support, it would be relevant for that time as well. You would include your notice of assessments for the last 3 years. The court really does. They will reject your materials,
Mm-hmm.
to say the least, if you do not have them attached to a financial statement when you're seeking a claim for support or making property claims. So please remember that you do need your notice of assessments for the last 3 years. So if you're thinking of starting a court application, put your mind to gathering that information from beforehand.
Yeah. And if you have children and there's parenting decisions that would be involved, then you need to include an affidavit for custody and access. Actually, it's probably not called that anymore. That's the old name. So there's an affidavit for... What's it called now? It's for parenting.
Yeah.
So for the uninitiated, on May 1st of 2021, the court... a lot of changes were made to the Divorce Act and the Children's Law Reform Act, and there's been a lot of change in terminology. So if we do slip back and say custody, for all intents and purposes, we mean decision-making responsibility, and access is now just parenting time. So reverting back to old habits and calling that the affidavit for custody and access, it no longer exists because we don't speak in terms of custody and access anymore.
Exactly. So that's kind of the first bundle that you would prepare.
Yes.
And in your application, it would be the material facts that you're relying on for your claims. So after you've completed your application, if the financial statement's relevant, you would have that. And if parenting is relevant, you would have an affidavit for parenting and decision-making responsibilities. And then from there, you would you would actually get the application issued with the court first. So that's, in layman's terms, it's just a seal for all. It's just a
and
fancy,
the signature of a court clerk.
Yes, it's just a seal to certify that you have everything ready. And then from there, you would actually go ahead and serve the other party. And you can't do that yourself. So remember, if you are considering being self-represented, that you have the appropriate mechanisms in place. That has to be served properly.
Yeah, and it has to be by personal service, so it's not appropriate to just mail it to them. In this case, now with COVID considerations at this point, I'm not really sure what the rules are regarding personal service.
So you can actually do you can do email, for example, or alternate to personal service, but you do need to take additional steps to make sure that it was served, that you had consent to do it that way, and that they acknowledged service. So if there's another lawyer on the other side, service via email is a little more appropriate because they can actually prepare the acknowledgement of service and confirm that they received service, and then that way you could file your materials, which would be the next step.
So under normal circumstances, you want to have a process server actually take it over to the other side and hand it to the other person, and they would usually prepare an affidavit for you.
Yes.
Right?
So as soon as that's done and they effect service, so sometimes they may have to take multiple attempts, but let's say service is effected. So service takes effect the next day, and from 30 days later, that's when they're required to serve the responding materials. And a responding material is an answer.
Yeah, I want to jump in there and say it's 30 days if they're in Ontario.
Oh, yes.
So if they're outside of the jurisdiction, then they get 60 days.
And then if they're part to any signatory countries that require special service, you might actually have to go through that process first. And,
that's a very interesting subject, and we cannot even touch on that today. So
we're imagining you're in Ontario,
yes,
and it's more of a simplistic procedure from there. So within 30 days, they have to respond with their claim, which is an answer. And let's say you are now served with an application, and what do? You would actually prepare an answer, and in this document, you can actually agree with some of the claims in an application, or you can make your own claims. So say, no one talked about spousal support and you believe that you're entitled to spousal support and you want to put that claim forward, you would check off that claim and then the material facts that support that as well. And then if you're responding to a claim for property division or support, you also need to prepare a financial statement, and if there's property involved, it requires a more complex financial statement, which is a 13.1 financial statement. But I don't think we need to go too much about the forms. And then again, if they've brought up claims respecting parenting, then you would also need your own affidavit for parenting and decision-making responsibilities.
Okay. So after you've for the answer, you really just have to serve it on the applicant.
Yeah.
And if you think there's any other party that needs to be added, then you can make them you can add them to the process at that time. So an example would be if there's property that's involved that maybe belong to a parent, and you feel that it's important for that parent to advance their own claim, then you can add them there. So there's ways around that. If we try to explain it, it may sound more complicated, but in the most simplistic form, the first person files the application and whatever other forms that they're required to, if they're, depending on what claims they're making, and then you have to file your answer, and you might have to file, similar forms as well if they're asking for support, property division, or parenting, orders as well. Exactly. And then there's the reply. So after the answer is filed, the applicant gets 10 days to file a reply. Here's a rookie mistake I see all the time with even young lawyers, which is filing a reply to dispute the claims in the answer. You can take it for granted that the judge knows that everything in the answer is untrue and you don't agree and you dispute it. Don't just, to put it simply, let's say A says, I want, I'm trying to think of a simplistic example, but the point is, if it's something material, then obviously file a reply. But it's not a reply.
It doesn't go towards the substance, I think.
Yeah.
So if they're just irrelevant facts, maybe to inflate the situation and, putting irrelevant examples about incidences that happen. I mean, sometimes when a situation of abuse is brought up out of nowhere, sometimes people, I get the urge to
No, that's different. So let's say something like, I took John to the playground every single day. You don't need to reply saying, no, he only took John to the playground Mondays, Wednesdays, Fridays, and weekends.
Or that I make all of the dental appointments for the children. So things like that, things that are not really, you'll get a chance to refute that, but in a reply, it's really not necessary. So think of a reply as only necessary to substantive relief. That's not, or something that's new that was brought up. And not just new as in a new fact that's not material to your claims.
So that's, I know I see that with replies a lot, and I wonder what was the point of this lawyer or this other party filing a reply in the first place? Like, you're just supposed to be replying to new claims. So if you just asked in the application, if you only asked for parenting orders and now someone's raising support, then it's appropriate, if you disagree, to file a reply speaking to that issue of support and why you disagree with that order being made. So it's not about just arguing every immaterial fact. And I tell people, just assume that the judge is not thinking by any stretch of the imagination that because you didn't file a reply that you agree with everything that the other party has said. The pleadings is really not even the best place to argue the facts anyway. You will get your chance to do that much later. Mm-hmm. And I just use the word pleadings. And
So pleadings are really the application, an answer, a reply. Things like this are pleadings, and they form part of the court record. So when we go into like conferences, we'll talk about, the different documents and things that actually stay in the court file versus just getting, given back to the parties or just stricken from the record after the fact. I wouldn't say stricken because that's a more legal test, but really that they're not going to stay with you. So when you're going to a trial, these are the materials that you're going to rely on. Know that in this process, you can also amend these pleadings at any point. So let's say in your initial application, you didn't think about, or you didn't have a lawyer and you didn't put a claim for spousal support or a certain thing that you wanted to. Mm-hmm. You could always amend with the court's permission, and within a certain timeline, you could just amend without the other side's permission. But to be honest, by that point, you're most likely going to need the court's permission, and it's past that timeline. Yeah.
So once you have the answer, the application answer reply, then the next step would usually be your first appearance if there's no property claim.
Yeah.
If there's a property claim involved, then you're probably going to have to be scheduling a case conference.
Yeah.
So your next step after all of these materials are filed, and I'm imagining they're filed within the proper timelines, right? Sometimes they're not, and then
you get extensions.
Exactly.
And it's not uncommon. I think you can attest to that. So it's not uncommon that you have extensions, and there's no automatic date. When you have a first appearance, I think we'll just briefly touch on what that is. It's a purely administrative court date, and it's in front of a Rule 39 clerk, which is essentially a clerk that just wants to ensure all of the materials have been filed, and now the parties can go ahead and book their case conference.
Exactly. Yes.
So it's not like to be nervous about. A lot of people get really stressed out about it. Mm-hmm. But it's purely administrative. Either, the party can attend or your lawyer alone. And by this time now, they're really just doing teleconferences. Yes. So it's all on the phone.
Yes. So after your first appearance,
if applicable,
then exactly. Then you would, at the first appearance, they'll book a date for the case conference. If you don't have a first appearance, then you would have to proactively book the date for your case conference. And that's the most exciting date for me actually, because that's the first time you get your case tested by a judge.
Yes. I would say this is the most monumental time. This is like really where you can assess your position. Yes. This is probably the most stressful time. I mean, other than trial, I guess.
But I guess for the clients, for me, I always tell clients, like, don't worry too much. The powers of a conference judge are very limited. they limit it of their own volition for the most part, because there's some orders that I think the case conference judges can make, but they don't. They really stick with that role of just trying to facilitate a settlement. So for your case conference, you're going to need a brief, and it's called a case conference brief, very unique name. And again, it's in check. There's a lot of check marks for you. It's a form with a lot of check boxes for you to go through. And there's areas for you to enter your facts as well.
Exactly. And this is probably where more the detail comes in, and where I kind of, I try to tell my clients, what the things that you really wanted to bring in the application, those things that were more detailed, things that weren't really substantive, but now can be addressed. This is kind of where they go. I mean, I'm not saying everything under the kitchen sink.
Well, we have strict page limits these days.
Because sometimes judges might gloss over it, but the reality is they're seeing so many different cases and they have large caseloads. So you need to make it concise, you need to make it to the point, but as well, you need to be, you need to provide those facts and those details that are appropriate.
Yeah. So at your case conference, the judge would try as much as possible to narrow the issues for you, right? So settlement is always the goal, but at the very least, they want you guys to come together and really narrow the issues as much as you can, because sometimes people just throw every claim out there, and the judge, and I mean, a lot of experienced lawyers would do that between themselves anyway before the conference, and that's the way it should be, so that your case conference is more efficient. But in a case where, people just can't see eye to eye, then you get the opinion of the judge. My favorite part is hearing the judge disagree with me, because I recognize that sometimes I am so tied to the case that I might be looking at things through a tunnel vision. And I know it's very difficult for my clients to hear the judge disagree with them. It's not fun for me, but I know it's very valuable. So I always coach my clients and say, you might not hear me arguing with the judge, because that's not the point. They're not going to make a decision on your matter that day. They're not even likely to make a decision on your matter at all. But I want to hear from a third party that's not the other side, the weaknesses they see in my case. And I don't necessarily agree with the judges. It's not about agreeing or disagreeing. It's about hearing what somebody else that's in a position to make a decision on my matter, how that person views my case. And all I have to do when I leave in the areas that they disagree with is I can tweak my arguments a little bit. I can adjust my position, because the goal is to get my client the result at the end of the day. It's not about winning points with this one judge. Now, having said that, obviously there's a psychological effect that comes with that, because you don't want the other side overly empowered and thinking they're right just because they've heard it from a judge. Yeah. So we try to strike that right balance. There's a time where you need to really clarify to a judge so that they don't overly, empower the other side in their position. But there's also times where we're quiet, not because we can't argue, but because we're taking notes, we're listening. With the judge may have hit a point that we didn't see in our case, and we know that if we add that or we tweak things, it would make your case even better. And honestly, sometimes you may even get a completely different and better angle for your matter that you may not have even seen, right? So just trust us sometimes when we're not just jumping up and arguing with the judge.
Yeah, trust me, it's never gone well when you argue with a judge. So that's one word to the wise. It's not, I know sometimes, it's the TV of all of it, but it's never wise to argue with a judge.
Yeah. So another important reason, or I know what makes the case conference significant, is the fact that we can't bring motions before a case conference.
Yes.
Except
in the case of urgency. And the tests of urgency are, there are different areas. So if there's dire financial need, if there's child protection matters that need to be addressed prior to a case conference,
and I would just say dire financial need, they mean dire. It doesn't, if you have a line of credit you can use and it's not $0 and your door isn't being broken down by the banks. Like
there's no
it's almost
closure,
not urgency.
You don't need that. Yeah.
You know, so let's just put it simply by saying it's a very hard test. It's not impossible, but it's a very high threshold. And so the reason, and it's very simple. The courts really want to discourage people bringing motions before having that opportunity to sit down and hear the recommendations of a judge regarding their matter, before having a judge, because the judges do try, like a lot of consent orders. I would say many of my case conferences end up with consent orders, right? Both sides.
What are consent orders?
Yeah. So consent orders are when both sides agree. So I had said earlier that the judge at the case conference is not likely to make an order on your case.
Unless it's more
unless both sides agree.
Those are the kind of
even then at a case conference they're very it's very,
if it's necessary disclosure, such as very basic financial disclosure, you will get that order, or they will strongly.
No, even child support they will. Yeah. There's a lot of orders they have the powers to make, but for the most part a lot of them focus on just trying to narrow the issues for you guys and that sort of thing. So having said that, the consent order is sort of the way to go about. Many of them would, if one party is not providing disclosure, usually it's because of reasons that maybe are unreasonable. And so, having heard from the judge, they would usually, for the most part,
change their positions, at least narrow down the issues. And that's the point of a case conference, and really any conference. And their role is to narrow the issues between the two of you. And so, when you reach a settlement on the different disclosures, you get the judge's recommendations regarding disclosure, potentially any other issues. So
if you guys agree, you sign that, you get an order. You write in its simplest terms. You write out the terms you've agreed to, and it gets made into an order. That's really a consent order. Is an order that both sides agree to. Okay, so, I kind of forgot where we were going with that. So we were saying the significance of the case conference is that after the conference, you don't need to show urgency to bring a motion, which is great, because if you're not getting your order at a case conference, if you can't meet the test of urgency, but you cannot afford to wait, you can't afford to wait any longer, and you really need that, interim order, then a motion is the way to go. So Sherine, do you want to explain very briefly what motions are?
So motion is either an interim or a final decision, especially if it's something more like parenting schedule or something small, a pickup location. If you need spousal support, they can make an interim order respecting that. If you need retroactive support, that would most likely be a final order. But things like that you need an interim decision on, because the case management judge does not have the ability to award such orders, and you need to go ahead and get that determination. You would bring a motion. Do you want me to go through the procedure of the motion?
No, I think we should leave that for another day, because it's a lot. But in its simplest terms, if there, a motion is a proceeding that's used to deal with issues that cannot wait until a trial. Mm-hmm. Because when you start that application, the end is the trial. That's really the very end, a trial, and the judge makes a decision. But there's lots of steps as we're going to go through, as just still at the case conference stage, and this is your first time in front of a judge. And so if you're if you have an issue that cannot wait until trial, then a motion is required to deal with that. And obviously there's a lot of forms that go with a motion and things like that.
Timelines. I mean, I'm sure lots of you have heard what motions are. But for our purposes, it's really just a determination on an issue. So
after the case conference, it's really, at least it allows you to bring that. Now, please don't mistake this for me saying you should routinely bring motions. I don't think it's a good idea. I think consent orders are better. I think it's always better for the parties to come to some sort of agreement between themselves. But sometimes your hands are forced and you just can't wait. Frankly, for me, if an issue comes up and I have a settlement conference, for example, in a few weeks or even a month, and it's something that can wait, I would wait to get to a conference before bringing a motion.
Yeah, because sometimes you might actually settle at the settlement conference, which would be the next step after a case conference. And in that in that process, then you're saving yourself a lot of the funds because motions can be pretty costly.
Yes.
So definitely, if you're able to get the judge's recommendation about the motion, and you can even ask, like your lawyer or yourself can ask the judge, if they were sitting this motion, what their decision would be on the issue. And, it may be favorable to you, and it would definitely urge the parties to settle.
Yes, exactly.
That issue, at least.
And a lot of cases get settled that don't settle at the case conference stage, settles at the settlement conference. So I think we just started talking about the settlement conference without even leading into it. So after your case conference, the next appearance at the court would be a settlement conference. And these steps, for the most part, are mandatory. Like, it's required by the rules.
Similar in nature. Like, the materials, you need to prepare updated financial statements. You still need to prepare a settlement conference brief. The difference in a settlement conference is you actually have to prepare an offer to settle on the issues. So the judge needs to see that you guys have been making some reasonable headway, and there is some sort of offer that you're proposing to settle all of the issues. They need to see some sort of movement.
Yes, and another thing I sometimes don't see at settlement conferences, which irks me sometimes, is people don't file net family property statements when there's property involved. And file multiple formats if you have to. Even if we disagree on something, prepare a comparison for the judge to see. You're at your next court stage, be a little bit more prepared. It's every court step, I think, takes time and money for the parties. So don't be prepared. Don't come unprepared.
And for those of you wondering what a net family property statement, it really is both of your financial statements if there's property involved, and it's just a combination of both of them together. And so the judge, and if you have difference of opinions, then there's a comparative for the judge to follow along. So not only is it made it easier for the judge to provide their recommendations, they now have a starting point to look at, and they can actually see what the differences are, and it really helps move the case along.
Yeah, and in the future, we'll talk a little bit more about the net family property statement, but just understand that it's one of the materials that you're going to need as part of your court process if there's property issues involved. And so when you attend your settlement conference, if you're not prepared, if the issues are still not narrowed, if there is disclosure outstanding, if someone still, I don't even know.
If something is just not where it should be at the stage of a settlement conference, good for you. They get to put you to another settlement conference.
Yes.
And trust me, when I say that there's no end to how many settlement conferences you can have, like I could tell you, I mean, to be honest, I think the most I've maybe seen is 4.
Yeah. Well, I've not been that unfortunate, thank goodness. But even by the second time, right, it's frustrating for you because you're in front of a judge that's not going to determine all of the issues, right? And that's why it's important to be prepared. And I know that we're all guilty of this. After court, we put things aside and then it only comes to mind before the next court date. It's not the most efficient way to do things. You really want to take advantage of that time between conferences. So a lot of cases, right? Keep momentum going. I know, because when you drop it, then it's just like,
yeah, even for the parties, because it's a cost, and then
exactly
then they want to recuperate sometimes, but the momentum is sometimes the most fundamental part.
The good thing with these conferences is for lawyers that are not very proactive during the waiting periods, at least it forces us to have a conversation.
Yeah.
So a lot of times, back in the good old days, because when we could actually go to physical court, you were in the hallways and you're waiting for the other party to be done, and so now you're just stuck with this other lawyer. It forces a conversation, right? But now the courts are awesome in that they would, throw you into breakout rooms and you can have these conversations. And I'm happy that even with our virtual courts that we're able to still facilitate settlements in our respective breakout rooms and all of that. So anyway, so I'm just going to recap again. You filed your application. You have the answers done. You've done a reply if necessary. You've had your case conference.
You've had a settlement conference.
And now you're at a settlement conference. You've completed that successfully. Now where do you go next?
So the next step would be a trial management conference.
Yeah, and the purpose of the trial management conference is to further explore the chances of settling your case. A lot of cases settle at this stage. Don't forget, only about 3%, I believe, of family law matters actually make it to the trial. So the judge will try their very best to see if your case can settle at this stage. And if that's obviously not happening, the judge will try to organize how your trial would proceed, right? So, you guys would set timelines for making sure that expert reports come in on time. You will estimate how much time each party needs for their witnesses. How many witnesses are you calling? What are the names of these witnesses? What would they be testifying to? If there's going to be an agreed statement of facts, for example, the trial management conference is when you get to organize that and sort of set the timelines. So you would also be set down for the next trial sittings. And by that, I mean, in the unified family courts, trials happen at specific times throughout the year. So in the Oshawa courts, for example, there's usually the May, and I believe it was November trial sittings. So if you were having your trial management conference at this time, you would be set for the May trial sittings. And what that really means is, I'm not sure you want to go over that.
It's really just like a period of time, usually comprised of about like 3 weeks. And you can get called at any time. So it's not like you're getting a date for May 14th, for example. You don't actually know what the date is. And it's just kind of, sometimes they call you a day or two before and they let you know that your trial's proceeding on so-and-so date and to be ready. So we'd hope that you're at that time ready, because that's intended what your trial management conference is for. You're supposed to, have those timelines prepared so you know what needs to take place.
And I mean, if you did, the bummer with not having a date is if you just have to let your employer know, if you're self-represented or even just for attending court, that
or your witnesses
within short notice.
They need to be on hand. So like that's, I think, sometimes a little more difficult when there's not a structured time. Because then, you have to get the witnesses all in line on every single day, not knowing.
And I mean, we do try, though, because we already, on our part, we know how we want to organize the witnesses, who we want to call first and things like that. So we will, we could tell someone when to come and things like that. So don't come on the first day because we're starting with witness X and things like that. But obviously things don't go
sometimes they either proceed a little faster, a little, sometimes they may even take longer. Yes. So you never know.
Yeah. So, but anyway, that's, you only try, and the goal of the judge at the trial management conference is to at least estimate overall times. I think it's very frustrating for the judges to set a trial down for a week and it ends up taking 3 weeks, because there's other people that are scheduled to have trials at that time as well, and there's limited judicial resources. So
it's also costly.
They want to make sure it's estimated properly.
And the more days of trial, the more funds it takes.
So, for everybody,
a determinant factor in how long you actually anticipate you going through the issues.
I mean, I guess a self-represented person might feel like, well, it's not costing them anything, but it's just life that you're using up being there in court. But again, the judges are always particular about proportionality, so they don't want 10 days taken to determine a matter that, from a legal perspective, is not that complicated, even though from your emotional perspective or from your situation, it means the world to you. Yeah. So anyway, all of that gets organized at the trial management conference, and you would also, so Sherine, let's kind of go over sort of the materials that you would need. And you usually file this after your trial management conference, but in advance of the trial.
Yeah. So expert reports, and evidence, you actually need to provide those in advance. And this is also for the report to also be read and to have a computing expert also testify or prepare a report.
So it's generally 90 days for you to file your expert report, and the other side has, I can't remember the number of days that they have as well. It's all in the family law rules they have, and it would also be on the form. So after your trial management conference, you would get, the forms back, the trial scheduling forms that would have set timelines, and it could exceed, or if you guys are comfortable with it, it might even shrink the timelines that are required by the rules. Yeah. You can also file your opening trial statements if you want. Yeah. You don't have to. I generally like to, because it gives the judge something to look at. And for me, just even putting...
It's like a nice summary of your case, and it really is just like a very concise statement about what the evidence that the judge intends to hear today.
Yes. So I like it for that. Yeah. So what I also, even though I submit written opening trial statements, I also like to speak to it as well in court. So I'm not necessarily reading what I've written, but it's kind of it all ties in. It all ties in, and it's nice for the judge to have, and even if you have to read it, if you're self-represented, it helps because then the judge can follow through. It just keeps you focused, right? So there's your opening trial statement. There's your book of exhibits. I don't know if you mentioned that earlier.
Yes, the book of exhibits is the evidence that you wish to tender as evidence to the judge. Not all of your actual, exhibits are going to be introduced as evidence, but that's really the book of everything that you want to bring.
So in a practical way, at trial, you might serve 1,000 pages as part of your book of exhibits, but all of it doesn't go to the judge. The judge only gets what's actually referred to at trial. So if you present, if you have exhibits A to Z, and during the trial, you only refer to A to C, that's the only thing the judge takes. That's the only exhibit that he's going to refer to in making his decision. And everything else, he's not going to deal with. So that's a very important point, actually. Sometimes people have the misconception that just because they brought their materials to court, you can just dump it all on the judge.
Yeah, it's not
happening. So you don't.
You can have months of text messages, but if you're not making specific reference to those messages, they're not going to be before the judge when he's deciding, when he's taking the evidence, deciding the final decision.
Absolutely.
So it's very important to know that. So in addition to the book of exhibits, you have your trial record, which are all the pleadings, any, updated financial statements or net family property statements that you wish to rely on. And any affidavits that you wish to rely on as well. Yeah,
if you've had motions and things like that, it would be in there. Any orders that have been made so far would all be in your trial record. Then you need to do a book of exhibits. I mean, at this stage, you've done your research. You know what laws are in your favor, and even...
So the book of authorities,
Yeah, what did I call that?
Book of exhibits.
Okay, so my bad. Book of authorities it is. So, and lastly, you have your draft orders.
So your draft orders are really everything that you're trying to actually ask for in the trial. You would, write them out. It's really a requirement. So you don't get the luxury of, just not preparing one. It also helps the judge too. So if he's making those orders, it's also readily
he could just
available.
copy and paste.
Right?
Wouldn't
Especially
it be awesome?
in the electronic world now that everything is electronic. Hopefully that's here to stay. So it's a little more streamlined.
Yeah, absolutely. And so that's it. After your trial, you can either get an oral decision at the end, or the judge might reserve their decision to be made at some point in the future. And
judges usually like to take it up to their cottages. So you might wait a couple months and for a very lengthy, written decision, or you may come back for their oral decision.
Yes. So, and that's it. So to kind of summarize all the steps we've gone through. So you've had, your application, your answer, your reply, first appearance, if it applies. You've had a case conference, settlement conference, or several settlement conferences. You've had a trial management conference or more than one. And you've also now had your trial, and hopefully you've put your best foot forward all along. You've put forward aggressive offers to settle, to make sure that you hedge against having to pay the other party's legal fees. And then all in all, that you just get your final decision, and
then you would address the issue of costs, and on the more successful party.
Exactly.
I'm sure you're not rushing if you're not the successful party to be addressing the issue of cost, but definitely something that you need to consider after getting a decision.
And we will do a podcast on the issue of cost, because that's also a whole different subject. But so that's your primer on all the steps in a family law court matter. As you know, each step, we can spend half an hour on each step and not even completely scratch the surface, but we just wanted to give you a high level overview.
Yeah, some sort of guideline, something to kind of, help with the framework. Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.